Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing what's been going on at the public inquiry into the federal government's use of the Emergencies Act, also known as the Rouleau Commission. The Emergencies Act was invoked for the first time ever in February 2022 in response to the Freedom Convoy. This inquiry is looking into and assessing the federal government's justification for invoking this extraordinary legislation. The inquiry is required by law and is being conducted by a judge, Commissioner Rouleau. The inquiry is calling witnesses who range from political leaders all the way up to the Prime Minister to witnesses from the RCMP, Ottawa Police, OPP, as well as political and bureaucratic staff. These witnesses are being cross-examined by the lawyers for the Commission, as well as the lawyers for the various parties to the Commission, made up of various non-government organizations, including the organization I work for, the Canadian Constitution Foundation. Now, I've been watching these hearings every day, and I'm really excited to talk today with the executive director of the CCF, Joanna Baron, about what has happened so far. So, Joanna, we have both been watching this inquiry basically nonstop. What have we learned so far about the government's justification for invoking the Emergencies Act?
Honestly, the theme that's emerging, so I think at this point they've been going on for 2 weeks. If there was something truly shocking and truly new about the justification, I think it's safe to assume that we would have heard it by now. There's been voluminous amounts of evidence. It's been described as a fire hose. And what's really emerging is that nothing was working. That, the narrative that's emerging is that even though there were different laws available, they effectively weren't being available. There was total chaos. There was many broken telephones going on between different departments and police departments, which I'm sure we'll get into. But that it was indeed an emergency. It was indeed completely chaotic. But in terms of the actual threshold for invoking the Emergencies Act, we haven't seen anything that would justify it.
Yeah, has there been anything so far about an actual national security threat, which is one of the justifications for invoking this type of legislation?
So there's a few things that the short answer is no. However, there's a few new things that we've learned. So first, we learned that there was apparently a bomb threat called in to the Children's Hospital in Ottawa. First, we'd heard of that. It ended up being a fake. And as you know, false bomb threats get called in all the time and don't amount to anything. And then the mayor of Ottawa, Jim Watson, or I guess we should say former mayor now, he gave evidence that apparently somebody was driving in from New Brunswick with a car full of guns and was threatening to attack him. There also were musings.
And that man was arrested by police.
Yep. Yes, he was arrested. Several of the police witnesses also mused on the possibility of a lone wolf attacker, which of course has happened in Ottawa before. But again, that's a threat that is theoretically possible at any gathering, even at any time in any place. So that can't be the standard.
Yeah, certainly the famous attack on Parliament, where a soldier was killed and a gunman entered the Parliament buildings, was precipitated by nothing. It was just a lone wolf acting alone. I think there was also evidence from the an OPP intelligence officer who said in a intelligence report there was a potential national security threat. But on cross-examination, it was very clear that he was saying this is a potential threat. There was never any actionable intelligence on a national security threat. So when it comes to that question on national security, it doesn't seem like we have actually heard anything so far. All that we've been hearing, from my perspective, is about a lot of dysfunction at the police force and the question of whether any other law could be effective. I mean, the threshold can't possibly be mere police mismanagement, police incompetence, bureaucratic incompetence. That is not the threshold for this incredibly exceptional piece of legislation. And certainly a lot of the evidence that we've seen indicates that the police were not working well together, the three different police forces. Anything you can tell us about that in about 30 seconds?
Yeah, well, first of all, it's pretty clear that the Ottawa Police Service misjudged from the beginning. Their assumption, and particularly Peter Slowly's assumption, was that people were going to roll in, spend the weekend, and then it was all going to be cleared by the end of the weekend. Now, it wouldn't have been, and I'm sure different police forces across the country who had been listening, who had been monitoring, who knew that the convoy was well organized, it was well financed. They could have indicated that no, this isn't just going to end in 2 days.
And
But
the OPP did tell him that he received multiple reports from OPP and from civilians, including city councilors, that was a concern. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing what's been going on at the Public Order Emergency Commission, or the Rouleau Commission, this inquiry looking into the government's justification for invoking the historic Emergencies Act. So, Joanna, let's talk about that legislation. What is the threshold for invoking that Emergencies Act? What does the commission need to learn in order to find that the use of the act was justified or not justified?
So there's a few steps that I'll have to go through, but I really think it's worthwhile because I feel like this has kind of been lost in the mix of all this voluminous evidence that we've been hearing.
And really, this is the most important question.
It is. So the government has asserted that it was a public order emergency, which is defined in the Act as an emergency that arises from threats to the security of Canada and that is so serious to be a national emergency. And I'll mention what threats to the security of Canada are defined as in a moment. But also important to mention that in order to be invoked, the crisis has to exceed the capacity of a province to deal with. And we'll talk about Ontario's contested role in this commission, or non-role, as the case may be. As well, the provinces have to be consulted. We know that the provinces feel they were not consulted, and Parliament has to approve it. But let's go back to threats of the security of Canada. They're pretty specifically defined. A, espionage or sabotage. B, foreign influenced activities. C, unlawful acts that are intended to lead to the overthrow of the government in Canada. Lawful protest is excluded except in combination with those. So we're talking about very specific things that we certainly haven't seen a scintilla of evidence of in these hearings.
So let's talk about that role of the Ontario government. So the one thing that has been a really interesting development is some evidence that the provincial government didn't participate in these tripartite conversations, that the provincial government could have used powers under their emergency legislation and didn't. And that's why the Canadian Constitution Foundation, we sent a letter to the commission asking that they call Premier Ford as a witness to testify at the inquiry. Now, Ford had said he wasn't going to testify because no one asked him. We received a reply from the commission that said they had asked the Premier and former Solicitor General multiple times to appear and that they declined. They then issued a summons in response to our request, summoning the Premier and Solicitor General, former Solicitor General, to appear. What has happened now?
So now Premier Ford has brought a judicial review contesting the summons, claiming that he is preempted by parliamentary privilege as a member of the Ontario legislature from being summoned to give evidence. And look, on the law, he very well may be right. Nonetheless, it's fairly jarring that the premier of a province, which is host to Ottawa, which contrary to popular belief, one of his talking points has been that this is a federal matter or just a policing matter. Just because the protests happen in Ottawa doesn't mean it's a federal matter. Ottawa is a city in Ontario, and it's important for us to understand what his thought process was in whether he considered invoking the Provincial Emergency Act, what his interaction was with the OPS and the OPP. And so it's really relevant to the question of whether this situation could have been dealt with under any other law in Canada, which is in some ways the crux of the matter. It's really the focus of the CCF's submissions. So I don't know how this is going to play for him. I mean, it's outside of the scope of our expertise to muse on why he's doing it, but clearly some of the optics may not be particularly politically flattering for him if he were to come, but it's still fairly shocking that he's refusing to participate.
Yeah, and that he said that he was not asked, but it turns out he was. And it's all something.
Depends on what you mean by asked.
Yeah, you're right. One of the things that I want to talk about is what powers the Premier could have used, because he had invoked a provincial state of emergency. But the powers under a provincial state of emergency are very different from Federal Emergencies Act. We've got about a minute. What can you tell us about those two different laws? And what makes the Federal Act so exceptional?
Well, the federal act, of course, applies across Canada, and it gives extensive powers to enact new criminal laws, sweeping powers that applied not just in Ottawa, but in every inch of Canada.
Which the
And it's
government
all
used. They did enact new criminal laws.
right. So
These regulations that allowed for the freezing and seizing of assets.
yeah, so you wouldn't have seen the economic measures if there had been a provincially declared state of emergency.
And I think that the premier could have used a lot of his powers under that provincial state of emergency. And there were existing common law powers that police have to create barrier zones that they could have restricted access to that red zone in Ottawa. We've got to go to commercial break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the Public Order Emergency Commission, which is going on in Ottawa, which Joanna and I are, our organization is a party to that inquiry, and we're watching nonstop. So, Joanna, one thing that the commission has spent a lot of time on is this question of whether the entrenchment of protesters in Ottawa could have been prevented. What have we learned about this? And when it comes to the question of whether it could have been prevented, does it actually matter as it relates to whether the use of the Emergencies Act was justified?
So what we've learned is that, as we mentioned before, there was a lot of broken telephone going on. So, for example, as you mentioned, it seems like Peter Slowly, the chief of the OPS, was warned that the protesters were well organized, that they were coming with enough money and food and supplies and they had booked up, I think, all of the hotels in the downtown
Or were at
core.
least claiming they were going to.
Right. And had sufficient funds and everything like that. And I think one thing that really came up and some commentators have written about is just normalcy bias, that it seems like Peter Slowly just like couldn't even believe that such a thing would happen because he was used to, the normal Ottawa protests, which go on a weekend and end. However, from the perspective, it's almost worrying to me that we're spending so much time in the weeds of that type of sort of cop drama, to put it in crude terms. It doesn't really go to whether the invocation of the Emergencies Act was justified. Protests can be inconvenient, they can be noisy, they can be disruptive, and we certainly have a lot of sympathy for the downtown Ottawa residents, but it doesn't make it a national public order emergency emerging from threats to the security of Canada. It's just not.
Now, one thing that does go to that question, though, is a number of policing witnesses who have said, in their words, that the Emergencies Act was not necessary to clear the protests, that the protests would have been cleared using the police powers that they already had, and they would have been cleared using the existing plan and on the same timeline. And a number of witnesses have said this. Now, they say that the tools under the Emergencies Act, they were helpful in various ways, but helpful is not the threshold for invoking this act. What can you tell us about that evidence, and does that create a problem for the government here?
Yeah, so I think all of the levels of police, we've seen evidence of the commission had come to the determination that they had existing legal tools, ranging from the tow trucks to bringing in officers to be sworn in, which one thing that we heard that we mentioned was, yes, the officers perhaps could have been, the additional reinforcements could have been sworn in a little bit more quickly, although it's not even clear if it would have made a difference with the invocation of the Emergencies Act. But what I would say is the talking point that the government seems to be shifting to, that even if there were other laws, the other laws and other commentators, the other laws were not effective, that they weren't, because there was ongoing chaos. So in practice, they weren't effective. If you have the actual people on the ground, literally the RCMP, the OPS, and the OPP, all of the boots on the ground, looking at the situation and saying, we have all the tools that we need to just go do it. It's pretty difficult for the government to fall back on that practical necessity talking point, I would think.
I think so too. I think the fact that so many policing witnesses have said this, even policing witnesses who might otherwise be, liked the powers that they had under the Emergencies Act, I think that the government's in a tough spot here. Now, let's talk briefly about those tow trucks. There's been evidence about how the tow trucks that the government says they needed the Emergencies Act to get these tow trucks. But a lot of witnesses have focused on how the tow trucks actually were on their way before the Emergencies Act was invoked. What do we know about this, and what does it say about the government's justification?
Yeah, so I think it was Superintendent Bernier gave evidence this week that there was already arrangements made by the OPP to deploy 34 trucks to tow away the trucks that were occupying in Ottawa, and they had also made arrangements to grant anonymity to the willing drivers, even to indemnify them against any claims. Then there was a little bit of, again, broken telephone, where there was a cross-examination by a lawyer representing the federal government. Apparently that at some point that plan fell through, and ultimately the Emergencies Act was leveraged. It turned out when the OPP commissioner, Thomas Carrick, was questioned by a commissioner lawyer about this, that, again, as you said, it wasn't that the plan fell through, it was just that the use of the Federal Emergencies Act to get the trucks towed was extremely helpful. And again, helpful is not the standard for the invocation of the Emergencies Act.
And I think some of Carrick's evidence related to the indemnification, which of course could also have been done under existing law. You don't need the Emergencies Act to indemnify a tow truck driver. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the Public Order Emergency Commission. Now, Joanna, our organization is a party to this inquiry. Who are some of the other parties, and what exactly is the role of a party? Just for the benefit of our viewers, obviously, we're participating, so we're quite aware of what our role is. But for viewers who might not understand, who are these different organizations participating, and what do they get to do?
So there are several sort of civil liberties groups like our own. The Canadian Civil Liberties Association is participating, the Justice Center, obviously Canadian Constitution Foundation, as well as Professor Ryan Alford. There's also the Ottawa Residents Association that's participating, Peter Slowly himself, to, I suppose, represent his interests and his legacy. Alberta and Saskatchewan are participating. And from their perspective, they were not effectively consulted. Of course, the Ottawa Police Service, of course, the federal government, and essentially all the parties' role. This is not a judicial hearing. This is not a court case. The role is to help the commission, which has a fact-finding mission to gather information, to present and test and elicit the relevant factual context leading up to the declaration of the emergency.
So the commission has to issue a final report. Is that report going to answer the question of, was the use of this legislation justified, and when can we expect the answer on that?
So its mandate is not specifically to find any type of formal legal finding. Our court case, which will be in January of 2023, will do that. It's more to look into the circumstances and produce a report. I would imagine there will be some judgments meted out, and there will be some parties that will be happy or less happy with the contents of the report, but it doesn't have any sort of binding force. It's function that is prescribed by statute that has to be completed within 1 year of the declaration of an emergency. So it's due by February 14th, 2023, which is a very tight timeline. So I imagine it will be very influential. It will be influential for future governments, but it will not have any binding effect.
And it certainly could be influential in our federal court case, dealing with our actual legal challenge to the government's use of this act. You know, I want to get to the high level picture, though. Why should Canadians be concerned about the use of this law, sort of irrespective of their views about the protesters' particular cause or grievance? A grievance I actually, I do sympathize with the frustrations of the protesters, if not their methods. I do not sympathize with a lot of those methods, but certainly the frustration with continued lockdowns, I do. But you know, if someone doesn't agree with that frustration, if someone doesn't agree with the cause of these protesters, why should they still be concerned about the use of this law?
So you have an literally unprecedented incursion into civil liberties, which happened in this country on February 14th, 2022. Of course, the seizure of assets, the freezing of bank accounts without a court warrant. But most people don't even realize there were things available to the police while that state of emergency was active that were absolutely sweeping. They could have clamped down on any gathering of people anywhere in Canada, even if no crime had been committed, no breach of the peace had occurred, if they had reason to suspect a breach of the peace could occur. The Emergency Act provisions that were enacted by this government gave them license to do that. And I think we just have to be very clear. We're looking at a picture right now, a fascinating picture, but a sort of dismaying picture of total bureaucratic chaos and ineptitude and miscommunications. And that's to be expected, I suppose. But we can't allow this type of chaos to amount to the War Measures Act and these incursions on our liberty. We have to just be very clear. And so that's why this case and our court case, sorry, rather the commission and our court case are so important, that we just need to be clear that chaos and inconvenience and noisy horns, while we don't dispute that there are big problems, they do not constitute a national emergency. And God help us if we ever face a true national emergency.
We've got to go, but thank you so much, Joanna.
Thank you.
We've heard today about what has happened so far in the inquiry into the Trudeau government's use of the Emergencies Act. In my opinion, nothing we've heard so far would justify the use of this exceptional legislation, which can only be used as a last resort. Have you been watching, and what are your views? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.